how do I sell a house that I inherited? Well, first of all, you are going to need to make sure that you figure out who the title of the property was in. If the title is still in the decedent's name, until their estate goes through the probate process, that estate can't convey title. So what you're going to have to do is, maybe you're the administrator, or maybe there was a will and you were named as the executor. You're going to have to go through the probate process, and you're going to have to basically get the authority and the power to sign the closing documents on behalf of the estate. So typically, if you are an executor in a will, a lot of times the will is going to grant you the authority to sell the assets of the estate. So you're just going to have to go through the probate process. You're going to have to probate that will. You'll have to file that with the probate court. You'll file a petition. There will be some other documents involved in a little bit of process and some waiting time and so on and so forth. But if ultimately the court is going to essentially validate the will, and they're going to say, hey, yes, this will is valid. You, John Smith, you can go ahead and carry out whatever the will says, and you become the executor of the will, or the executor of the estate, I should say. And at that point, you can sell the house. So you can advertise the house for sale, whether you want to sell it to an investor like us, or you want to list it out with a real estate agent, which we can help you with that as well. You have the authority to do that, because once you have your what's called letters testamentary, if there was a will and you're named executor, you're going to get letters testamentary. That is the court essentially validating the will and granting you the authority to sell the assets of the estate, in which case the house is one of the assets. So once you have those letters testamentary, you can sell the house and you can close on it. The money can't go to you personally. The money has to go to the estate. So make sure that you set up a bank account in the name of the estate. That's an easy way to do that. You'll have to go out to the IRS. You can get an EIN from the IRS. If you just go to irs.gov, there's actually, just follow the links. There's a way to get an EIN for an estate. There's a process. It's a pretty simple process, and just answer a few questions and fill in some information, and they'll give you an EIN, and then you take that EIN and you can go to pretty much any bank and open up an estate account for that estate. And that way all the monies that are owed to the estate, or anything that the estate needs to pay, goes in and out of that account. Again, you don't want to do that out of your personal account. You want to make sure you set up an estate account. So make sure you do that. And then that's all on the executor end. Now, if you go on the administrator end, maybe there was not a will, then you need an administrator. You need someone in charge of the estate. And you're going to petition for letters of administration with the courts. And once you petition for letters of administration, then the court will essentially, the same way that they do with the letters testamentary, is they're granting you authority as the administrator to sell assets on behalf of the estate. So you're going to go set up a bank account, just like I just talked about, but instead of being the executor, you're going to be the administrator. Once you have your letters of administration in your possession, you can legally sell the assets of the estate. The letters are going to grant you those authorities inside the letters. There'll be like a few sentences that grant you the authority to sell X, Y, and Z on behalf of the estate. And once you have that, then you're allowed to sell any of the property. We've had instances where an estate has been probated, they've received their letters of administration, and literally they got them that morning, and that afternoon they walked into the closing attorney's office and they sold us the house, signed all the papers, and my attorney was good with it because he had that document. He needs to have that document, those letters of administration that specifically grant the authority to be able to sell the assets of the estate. Once you have that, you're good. Now, the estate's not over with. Probate's not over with at that point. There's still more steps that you have to take. You're going to have to file tax returns. You're going to have to distribute the money to the heirs and all that stuff. But that's a whole different equation here. So right now I'm specifically talking about selling a house. And to get to that closing table, you're going to need those documents. So make sure you either have letters of administration or letters testamentary. Or if you inherited a house and you were one of the lucky few whose your loved one put the property in a living trust, then you just need the trust documents and you can sell the house. So that's the beauty of this. And then there are some minor circumstances, some exceptions where you don't have to go through probate, but they're very, very limited, and I don't really want to get into those. But it might apply to your situation, but don't get your hopes up, because most of the time you're going to have to go through the probate process. So I hope that helps. Again, we're a real estate solutions company at ArborView Property. So if you have a house you need to sell, you can click on the form, go to our website, fill out the form, and a member of our team will be in touch with you. We'll have a few questions for you. We're going to gauge your situation, what's going on, and try to put you in the right bucket. And once we determine that, then we can go down the process of getting that house sold for you. So thanks again, guys. We really appreciate your time, and have a nice day.